Good morning, ladies and gentlemen, and welcome to our webinar on the India data protection and privacy regime. Just a few introduction remarks that we have. This is a webinar where you can always post your questions. So you may always raise your hand and ask your questions and just put it in the chat on the right-hand side and just, ask your questions. Of course, we will have a Q&A session where the experts from our partner KHAITAN Legal Associates will answer all your questions. If you have any other questions after the webinar, you may also just contact us and we will get back to you. And then I'm now handing over to Sabina Pandey, the head of our office in Kolkata and head of our legal department. Sabina.
Thank you very much, Anne. Dear members of the Indo-German Chamber of Commerce, ladies and gentlemen, dear friends, welcome once again to our webinar, India Data Protection and Privacy Regime, A New Dawn. I'm speaking to you from Kolkata. As Anne was just mentioning, I'm the regional director of our office in Kolkata and also the head of the legal department. We have a beautiful monsoon day over here, so if you hear some background noise, it's most likely because of heavy rain showers and thunderstorm. So it's quite lovely. Our legal department offers German and Indian companies, for example, assistance in trade disputes to help settle them amicably. And we also give information in trade regulations and basic legal queries. We always work together very closely with the local authorities in India and with other experts. And today we are pleased to have with us the representatives of the Indian law firm KHAITAN to speak to us about the Indian data protection law. Whereas in Germany, since 25th May 2018, as we know, we have the basic data protection ordinance, or in short, DSGVO, as we say, which tells us how companies need to handle personal data. There is no such comparable regulation in India yet. But this is going to change soon, namely when the Data Protection Bill 2019 will come into force, which was already introduced in the Indian Parliament in December 2019. Thereby, of course, what interests us most is what German companies who do business in India have to observe and how we can prepare for the processes of the new data protection law in India. With this short introduction, I give back to my colleague, Ms. Anne Krieghaus from Düsseldorf, and I'm looking forward to an engaging session. Thank you, everyone.
Thank you, Sabina. So we're now starting with the presentation of our partners, KHAITAN Legal Associates. And I'm just handing over to our three experts, Ani Aya, Satyendra Srivastava, and Sangeeta Junjunwala. Satyendra, the floor is yours.
Thank you, Anna. Thank you, Sabina. A very warm good afternoon to friends who are joining us from India, and a good morning to friends who are joining us from Germany. So Sabina, in her very brief and not so detailed but very incisive introduction, stole my thunder. I was supposed to introduce the topic, and Sabina has already taken us halfway into it. So thank you, Sabina, for that. Now, given that most of us, most of the participants here are either representatives of German organizations or have been associated with German companies in some or the other way, I'm assuming that most of us are aware with the concept of data protection. Also, given the fact that most of us have been dealing with GDPR, I would also like to say that GDPR has been around for as Sabina pointed out, for more than 2 years now. The popular joke among us lawyers is that GDPR was definitely a creation of lawyers, okay, who wanted to ensure that businesses comply, and there is some additional compliance for businesses, and lawyers like us and consultants like us make money. Having said that, in India also, we are we're trying to do some such benefit for lawyers, although we are not there yet. And as you would see, from the slide, uh, it's a you know uh, it's it's a, uh, a different kind of a depiction of what things are in India at the moment. But it's not that bad it's not that bad either. Uh, you know, you would have realized that there are uh, occasions where which turn out to be defining moments that could alter the course of history. And I'm sounding very hyperbolic here, but in the Indian context, also data protection is something like that. The way we see it, that as and when the law comes into force, the it would have the ability to change the course of how India does business. Okay. Now, before I set the background and take you through the history of how things have evolved and how we have come to this stage, it is important to also understand India. And it in and the context of India, is it's important that you understand and realize. So see, India is a land of contrasts. India is heterogeneity personified. On one end, you have abject poverty, and on the other hand, you have opulence. On one hand, you have uh, you know uh, deaths because of malnutrition. And on the other hand, you have all the wealth creators, the largest concentration of wealth creators in the world. And similarly, digital divide is also as stark in India. So on one hand, you have the largest concentration of one of the largest concentrations of internet users, and on the other hand, you also have people who are illiterate. So any kind of a law or a policy, and that is a challenge with lawmakers and policymakers, that they need to reconcile and harmonize different interests while coming up with law. So while we believe in rebirth, the reason why the data protection law has taken so long to come into play is also because in India, lawmaking uh, is a process that can take time. Uh, so it's very important to trace the history, and uh, sometimes it's also full of a lot of humor. Given that the laws are created out of compulsion or out of pressure from business groups, and something like that happened for data protection as well. So the history of data protection actually goes back to the late 90s and early 2000, when India emerged as a top destination for IT and business process outsourcing. Uh, the what followed was these negative headlines all over the press in US and Europe about data theft, about breach of confidentiality, and so on, that emerged from India. So when the countries that were giving the outsourcing work to Indian companies, when they queried that, okay, what was the regime for protection of data and privacy in India, they did not get any encouraging response. So they, got together, and along with the Indian IT apex trade bodies and other activists and advocacy groups, they pressurized the Indian government to work on the creation of a data protection framework. Uh, and lo and behold, the Indian government did not have any option, but they accepted. But what did they do in return? Okay, the Indian government, tried to, as a gesture of, as a tokenist gesture, tried to do something with the existing Indian IT framework, and they tried to, make create a data protection regime. Uh, Interestingly, as lawyers, if somebody were to ask me that, okay, do you have a data protection regime in India? And sheepishly, I would have to say, no, it is there, but it is not there. There is no exclusive law. It forms a part of some rule-based framework as a part of the larger law. So, the country which has the largest, which is the longest written constitution, okay, summed up the data protection regime in 6 pages. So that is what happened, in around 2008 and 9, when the first, the reasonable security practices rules that came out within the Indian IT framework. That was India's first shot at data protection. But later on, as things progressed, as matters, as the regimes change in India, and given that there was a lot of noise about data protection also in jurisdictions like Europe with GDPR, the Indian government realized that they needed to put their house in order. So they set up a committee. And also, interestingly, around the same time, the Supreme Court of India, in one of the cases, recognized the right to privacy as a fundamental right. Now, that also led to the government coming under the pressure to do something surrounding data protection and privacy. So suddenly the government then accelerated, the Sri Krishna Committee report, and finally a bill was presented. I mean, the report was presented, and basis that report, the government then tabled the Personal Data Protection Bill in the year 2019. So, and this was tabled in the winter session, which was around December of last year. But in India, we have this interesting process that controversial bills or controversial pieces of legislation, they are referred to a parliamentary standing committee. So the parliamentary standing committee would then go through the law, invite objections, invite comments from different stakeholders, get into a dialogue, and then make necessary amendments and reintroduce the bill in the parliament. So as we speak, the Joint Parliamentary Committee, which was supposed to submit its report in February of this year, they got an extension, and they're supposed to submit the report on the data protection bill within next 2 weeks. The session of the Parliament is currently on. It it got inaugurated yesterday, the monsoon session, and it is likely that the bill will be tabled, not in this session, but hopefully either in the winter session or in the budget session, so around February of next year, if all goes well. So the question that you will ask me now is that if the bill is around 6 months away, then why are we discussing it now? Okay. And it's a reasonable question to ask. So the answer to that why is very simple. That the Joint Parliamentary Committee that is looking into the different aspects of the bill is not likely to change the fundamental edifice or the fundamental structure of the bill. So it's very important that you at least get oriented and introduced to how the bill looks like, what are the key issues, so that as and when you are dealing with your Indian counterparts or your partners in India or your other Indian interests, at least you hit the ground running and you have everything ready with you before the law comes and stares in your face. So with that, I would like to hand over the platform to the experts for the day, which is my colleague and partner Sangeeta Chunchunwala and Annie Arya. So over to you, Sangeeta. Please take the participants through the contours of the bill, and yeah, thanks.
Thank you, Satyendra, for that very, very insightful introduction and for laying down the foundation for this forthcoming session. Thank you so very much. Hello, friends, and Guten Morgen to my friends from Germany. And I would now like to sort of explain you the framework of Personal Data Protection Bill 2019. So this is where we are actually now stepping into the to be law, which is currently in the form of bill, as all of us know. I will broadly sort of set the framework for you people to just to have a sense of how the law has been how the law is proposed to be structured around. So, you know, to start with, let me give you the key notes of the bill. The first one being, let's identify what is being protected under the bill and what is not being protected or covered by the bill. So what we have done is we've divided in our presentation two buckets. So you would see one in red and one in black. I would like to first speak about the portion that's been highlighted in red marking, because that's what has been covered under the bill, which is well known personally identifiable information. My request is for the audience that, you know, when I'm talking about personally identifiable information, kindly consider it in the form of a pyramid, because that will help us understand better as to how the bill is structuring the data per se. So what has happened, the base of the personally identifiable information consists of the first bucket called personal data. Personal data, as the name suggests, very easy to understand. It's the natural person's data that we refer to, which basically helps us to relate to a person's identity directly or indirectly. And that information can be available to us either online or offline. So in summary, it's the personal identity of a person. Just to give you by way of an example, it could be name, age, sex, it could be your email ID. So information that is very, very personal to a natural person. I would just like to mention here a very pertinent point that the bill, when it covers personally identifiable information, it's personally identifiable information of a natural person. So that's a very key foundation to what we speak ahead. Now, the second layer of the pyramid, which forms the second tier of the pyramid that we're going to talk about, is as soon as you start attaching sensitive criteria to personal data, say, for example, health data, gender data, caste data, community data, financial data, the data becomes sensitive personal data. What happens with sensitive personal data is it's easily identifiable with the matrix that I just named it for you. So what happens is you identify the person, you know, with some objective criteria attributed to it, like financial, transgender, gender, sex, caste, community. By way of example, if I have to explain you, we just named, you know, that the name of a person becomes a personal data. But you know, very interestingly, what happens is in India, especially, the second name of a person, you know, usually indicates the caste, community, or the religion that the person would belong to. So, you know, when I've been sort of giving comments, reading reports of the various committees which is being proposed in the bill, one of the dimensions that's being considered while we say that the name of a person should fall into the category of personal data, but it has the attribute of indicating the caste community, you know, so that can also classify as sensitive personal data. So while speaking to you, I'm also bringing the dimensions of ambiguity that exist while the bill is taking its shape. Now, if you go to the topmost tier of the pyramid, we talk about critical personal data. Now, interestingly, everything that can be very, and that's an inference that we are drawing of reading of the bill and the report, because important to mention would be that critical personal data has neither been identified nor explained nor notified under the bill as yet. But as we saw, you know, the way personal data has been described, the way sensitive personal data has been described, our interpretation and assumption together would be that critical personal data would be something which is more objective in nature, which is more narrow in its identification, and therefore it would form the topmost tier of the pyramid that we are considering. Now, that's a broad category we spoke about on personally identifiable information, which is completely covered under the bill. There is a second category of information which is not covered under the bill, which is non-personal data. Non-personal data has been again classified under two buckets. Let's deal with the first one, called as anonymous data. Interestingly, if we focus on anonymous data, anonymous data is something which can very soon, fall in the category of personally identifiable information. The question is why I say so. Anonymous data is basically as soon as you retract information from personal data or SPD, which is sensitive personal data, as soon as you subtract identity, any attribute from an individual's data, and that data becomes anonymous, it's not easy, it's not possible for anybody to identify whose data does it belong to, and therefore it comes into anonymized data, which is outside the purview of the bill. But the information, the identity that I just spoke about, as soon as it's added back to anonymous data, you reattach the identity to that data and it becomes identifiable. And at that point of time, that becomes a trigger point where anonymous data falls back into the category of personally identifiable information and it gets captured under the bill. And all the do's and don'ts around the bill start applying to anonymized data. So just to summarize, anonymized data is something which is, as long as it is anonymized, it's outside the purview of the bill. As soon as it becomes denominized, as soon as attributes of identity are added to it, it becomes denominized data and it falls within the purview of the bill. The third category is an interesting category, which is completely, as of now, being excluded from the bill, and a separate committee is being formed around it to consider the aspects of that data, which is other data. As right now, no nomenclature has been added to that data. Other data would be basically data which is highly of economic value, something that can be very well monetized. To give you example, like data that's available from a Google map, data that's available, say like on your weather conditions, your climatic conditions, traffic conditions, all such data which is not basically and cryptically attached to a natural person but is of high economic value. It's available in general mass and is high in volume, accessible by the mass, is the category which is outside the purview of the bill, but a very key data because it's highly of economic value. So that's broadly how the data has been captured and defined under the bill, and that is what the bill protects, and that is what is outside the purview of the bill. Coming to the next slide, and a very important slide which I'm sure everybody would be interested to know about. Who are the key stakeholders under the bill? There are three key stakeholders under the bill. Even before I start, I would like to mention that the key stakeholders under the bill, they can please, I would request you to just keep this point in mind, that the key stakeholders in the bill, they are allowed to reside in India and outside India. The three key stakeholders under the bill are the data principal, the data fiduciary, and the data processor. All these three key stakeholders, they can reside in India or they can reside outside India. Now let's look at each key stakeholder, what that person holds or how it stands for. Data principal, like the name suggests, data principal is the natural person to whose data we are referring to. So data principal predominantly is the subject matter of the entire scheme of things that we are talking. The second and the most predominant one in the bill would be the data fiduciary, commonly to relate to my German friends, as you call data controller under the GDPR regime. So the data fiduciary is a person, or it's either in single or in conjunction with other person, who determines the means and purposes of the personal data. So data fiduciary, what happens is, again, data fiduciary is being divided into categories depending on the volume of data you deal with, depending on the turnover of the entity that you're talking about, and depending on the nature of data. Now, when I say volume of data, when I say turnover or threshold of an entity, if that kind of data is being dealt with, the person, the entity in control of such data will be known as significant data fiduciary. When you deal with when it's a category, say, of nature of data. So for example, if you're dealing with data in terms of when you're dealing with data where it relates to children who are below 18 years of age, that becomes nature of data. In that case, it's called as guardian data fiduciary. So the division of data fiduciary, or the bifurcation of data fiduciary, is basis the volume of data, turnover of entity, nature of data. Now, this is as of now the situation as we speak, as we talk. There is a possibility that the situation may enhance further, given the bill is still taking its shape. The law is still yet to be announced, yet to come. The third key and important stakeholder becomes the data processor. As the name suggests, data processor being the entity who actually processes the data. And in the scheme of things, there is a possibility that you even have a sub-data processor. Now, what I just talked about, let me explain you with the help of examples, so that you can have some sort of pictorial images, or you can sort of relate it to real life example. So let me give you an example where an individual is placing an order with, say, a brand called L'Oreal. Okay, and L'Oreal in turn uses the services of DHL. So in this case, what happens? The individual becomes the data principal. He's the subject, he or she is the subject matter. L'Oreal becomes the data fiduciary, because they are in control of the data of that individual, and DHL becomes the data processor. Now, in this, there is a very important point I would like to mention. There is a possibility that, at some point of time, the data fiduciary and data processor are one and the same person. The example for that could be, say, for example, for movers and packers services, I place an order with, say, DHL services. In that case, I'm the data principal, and DHL acts as a data fiduciary and a data processor, as long as DHL is not passing on some amount of its service task to any other entity. If there is a step down that's happening, there is a very well possibility that there could be an existence of data processor there as well. But it all depends. It's a permutation combination that we can see. And sometimes there is a possibility that, the same person acts as a data fiduciary and data processor, or vice versa. So there are criteria, like, the test would be like, actually when you explain data fiduciary, that entity is the person, that entity is the one who determines the purpose and means of processing of personal data. So that test becomes very important at the time of we doing that kind of a test. Now, I give you one classic example for, say, guardian data fiduciary. In case of schools, where most of the data is of children who are below 18 years age. In that case, the school becomes the guardian data fiduciary as well as the data processor. So these are some simple permutation combinations that I talked about, but there could of course be more. And I'm sure each one of you, when applying it to yourself, you could think of some more examples. But these are some simpliciter ones, just because we are touching the framework today. So just to sort of give you some insight. With this,
So, Sangeeta, sorry, can I ask you a question? Sorry, can I ask you a question,
please.
Sangeeta, here?
Please.
Sangeeta, will in a particular situation, can it so happen that the data fiduciary would be, the same person could be a data fiduciary in one context, and in the other context, he would be a data processor, right? And is it also possible that it could be one and the same entity? So, like, one entity would be a data fiduciary and a data processor both.
Yes, Satyendra, there is a possibility. So, like I just said, there are various permutations and combinations in which this entire process will work. And it will also depend on, so when I'm talking about DHL, we saw DHL in two roles in two different examples. In one where it's taking the order from L'Oreal, where it becomes the data processor. And in the second example, where it's direct service provider, it itself holds the data, controls the data, processes the data. So it acts as a data fiduciary and a data processor. So it's a two-in-one role. So your question is very pertinent, and it sort of hits the nail on the stone to say that yes, there is a possibility of overlapping. There's a possibility of, for organizations to lay down well set tests to identify who falls in which shoes. So if that answers your question.
Yeah, thank you. Just a small point. Your love for French brands, and thankfully you also included DHL, which is a German brand. So Here we go.
Thank you, Satendra. This goes a long story. I think we'll take audience someday through it because they are going to be a part of our long journey. I know, I'm very sure. With this, I invite upon my colleague Annie to take the audience with the rights and obligations set around the bill. Annie, over to you, please.
Thank you, Sangeeta. Thank you, Satendra. Good afternoon, everyone. Good morning in Germany. As you can see on this slide, essentially we talk about the rights of a data principal. Fundamentally, one would say that the data belongs to the principal. So colloquially, a lot of entities go on to say that the data is mine and I should have the right to do whatever I want with it. That is principally not the case. The data is in the control of the principal, and as such, there are certain rights that the data principal enjoys. The data principal has the right to ask all sorts of questions regarding the processing of data. What is it that what is the data that the fiduciary is processing? What is the manner and what are the tools applicable to such processing? Who are the data processors involved in the entire service cycle? The data principal also has a right to ask the data fiduciary to update its data and keep updated records. The data principal has the right to ask the data fiduciary to show them their data, and also right to erasure and right to be forgotten. You would see there are a lot of concepts over here which are overlapping with the GDPR. For example, right to access, right to erasure, right to have all of those questions asked. So it is fundamentally very, very close to where the GDPR stands on rights of data principle. Simultaneously, we would also need to speak about obligations of a data fiduciary. Data fiduciary would need to give notice to the data principal on what it is that they require from the data principal, the purpose of that requirement. They are required to give notice of who is the processor involved. Over and above all of that, the very fundamental principle inside the bill is that it is consent driven. We will see later on in one of the slides that in fact it is so fundamental to the bill that there is a concept of a consent manager which has been allocated under the bill. Over and above that, obligations would be, as a data fiduciary, I would only collect what is needed, and not because I have access to the data principal collect more than what is needed. The purpose for which I would collect that data would need to be lawful. I would have an obligation to keep complete and updated information. Very similar to the GDPR is the privacy by design policy, which would mean that I, as an entity, would need to consider data protection and privacy standards at the very inherent stage of incorporating my entity and keeping it as a very fundamental, inherent, intrinsic part of my processes and not as an afterthought. It is not something where you would just put in the staples and it will work. So that is what is sought to be. That is the aim with an entity having a privacy by design policy. And lastly, of course, the data fiduciary is required to have a grievance redressal mechanism. Over here, essentially, there would be different categories of compliances for a data fiduciary, significant data fiduciary, and a guardian data fiduciary. So this is the very base of what is required. As we move up to the categories, we would see stricter compliances and even more accountabilities and everything attached to those compliances. For example, for a significant data fiduciary, one would be required to appoint a data protection officer. So things like that, compliance would get, obligations would become more stringent. But this is the very base of what everyone is expected to do as a data fiduciary. One thing to add is data fiduciary is primarily given the responsibility of data processors under the bill. So all sorts of obligations which are put on data processors are also obligations of data fiduciaries. When we talk about consent, which is it is a very large concept under the privacy laws. Again, no consent, there is no data. The manner of consent fundamentally mimics what is required under contract law. It should be free, it should be informed, it should be specific to the purpose, it should be clear, and it should be capable of being withdrawn. Obviously, consent requirements for processing SPDI, which is sensitive personal data or information, has a higher level of threshold. For example, if I am processing personal data, I may also deem consent through conduct. For example, if a person has not outrightly said that they do not want their data to be processed, I may continue to do so. However, if I am processing SPDI, I would need explicit consent. So some of these thresholds are just different vis-a-vis whether you are processing PD versus SPDI. And then again, critical personal data, it's yet to be seen. What we do not require consent for, there are certain exceptions which have been provided under the bill. For example, any medical treatment or health service, if that needs to be provided to the individual, if one is responding to a medical emergency, if one has been given an order or a judgment where the court or tribunals in India required submission of data to meet certain compliances, if any disclosures are required under the law. These are just some of the instances where one may share data and transfer data and process data if consent has not been obtained. Sangeeta, I would now request you to please take everyone through Crossborder, please.
Sure. Thank you, Annie. So by now, as we set the framework of the bill for the audience, by now you would have understood we dealt with, kind of data, stakeholders, rights, obligations, and now as we move, we sort of higher the stake of the game that we are talking about today. So what happens is, like we discussed, the pyramid that I talked about, personal data, SPD, sensitive personal data, critical personal data. So now the most key issue and the deliberations, let me just say a caveat here before I proceed. Cross-border transfer of personal data is very heavily being debated, is very heavily being considered, because it's going to have a huge impact, as we even understand from the title of the slide itself. Personal data which is neither sensitive nor critical, there is no restriction around its transfer or its localization. As soon as sensitivity to personal data is attached, it can be transferred. So the flexibility of transfer for the purposes of processing outside India does exist, but localization has to happen in India. That's a ground rule that's been stated in the bill. Sensitive personal data can be transferred outside India for processing, but there are two scenarios that have been laid down under the bill. Like Annie had mentioned, consent is something very key across the obligations of data fiduciary and as a right of the data principle. So in the first scenario where we're talking with SPD is transferable for processing outside India, the key points out there would be express consent, which is very essential, and that transfer is pursuant to either a contract or an intra-group scheme which has already been approved by the Data Protection Authority. That's the first scenario in which a cross-border transfer of SPD is permitted. The second scenario is where the government, something similar to say a whitelist has been created, where entities, organization, countries have been listed. They are safe countries. The tests between the two governments have already been explored, and everything sets in round. So the transfer is happening to any such central government allowed whitelist country, and again the Data Protection Authority has given his consent for such a transfer. So these are two scenarios under which SPD is transferable, but I repeat, localization of data has to happen only in India. Localization cannot take place anywhere else in the world. The key difference between sensitive personal data and critical personal data, as the name suggests, is its criticality, and thereby, in case of critical personal data, you cannot transfer critical personal data outside India. So that's the ground rule. The only exception in which case critical personal data can be transferred outside India is in case of a provision of a health or an emergency service, or again where a country as approved by the central government is in its whitelist for the purposes of transfer of critical personal data. So that's a very key thing, and as like I said, you know, the deliberations around it still continue to take place. Now that's we've talked about a very key aspect of cross-border transfer of SPD and CPD. There are certain scenarios, there are certain kind of situations, there are certain kind of data which are exempted from the bill. We've already discussed anonymized data in our top slide. Then there is data which is very essential for the journalism purposes. This kind of data is also outside the purview of the bill. There is a possibility data is required for a high level research, archiving or statistical purpose. Let me give you an example when I'm talking about this. So it's not like a normal research archiving taking place. As you must all sort of have heard across the globe in news, it was that, you know, India experienced a historic day last month when the foundation for Ram temple was being laid in Ayodhya. Any kind of data being used in that kind of that status, that caliber of a research, archiving or statistical purpose, that is outside the purview of the bill. So it's not in like a normal UN course you're using some data and that's outside the purview of the bill. No, not that kind of research and development. Now, anecdote to it or a contrary situation to it would be any small entity which is not highly sophisticated in terms of its technology, automation, that kind of an entity sort of processing data would be outside the purview of the bill. So in India, you know, you have these unorganized sectors, you know, so, you know, it can be an unorganized sector, say where you obtain the data of natural person, their personal data, their SPD for various purposes, say for an unorganized lending business, I would say. In that case where, you know, you are outside the purview of the bill. But I would say these exemptions are right now in a broader category. I have not named all across on the slide because it's self-explanatory and legible. But I would say that while these are just broad category exemptions that have been stated in the bill, there will certainly be litmus test criteria which will be set against these exemptions also, because the possibility of misusing these exemptions otherwise would be very high. And in a country with a vast population like India, we cannot afford to have a wide range of free flow exemptions without any litmus tests being set around the hooks of it. With this, again, Annie, I request you if you could take some next few slides so it gives me a sort of stopper to breathe.
Thank you, Sangeeta. Essentially, if there is a data breach, the data fiduciary is required to inform the data protection authority of such breach as soon as possible. Data fiduciary is fundamentally not required to, on its own accord, present that report to or like sort of communicate that breach to a data principal. That is actually left to the wisdom of the data protection authority, and the data protection authority would determine on a case-to-case basis whether breach is required to be reported to the data principal. At the very least, what the data protection authority would do is it may direct data fiduciary to take certain remedial action which would mitigate such future breaches, and conspicuously post the details of the data breach on its website. And if at all it is required, then the data protection authority would take a call and require the report to be given to a data principal. What is very interesting under the 2019 bill, which emerged from the comments to the 2018 draft that was circulated, was the introduction of a sandbox concept. Essentially, there are certain criteria which one needs to meet. What the sandbox would look after is it would provide a controlled environment within which certain innovations in artificial intelligence, machine learning, and any other emerging technology which is there in the public interest, one would be able to explore those innovations within that controlled environment. Of course, one of the primary criteria is that the entity has a person who's making that application to the data protection authority to fall into the sandbox environment would need to have a privacy by design policy, and that privacy by design policy would need to be certified by the Data Protection Authority. Applicant would then need to provide an application, and there are certain requirements under the application. However, once those are met, the Sandbox entity can actually innovate without the ambit of the bill being applicable for a certain period of time. Very pertinent to this conversation is the penalties of a data fiduciary. There are certain breaches and offences which would attract criminal liability, which can also, as under the bill, look at imprisonment. The monetary penalty is very similar to what it is under the GDPR, as 4% of the total white turnover. But there is also a fixed amount of 1.7 million euros, which is a sliding sort of a scale, which may go up to 1.7 million euros or 4% of the total worldwide turnover. What also becomes relevant to this conversation is there are a lot of entities, and there must be a lot of our participants who are already GDPR compliant. What we would one would need to look at is what is the similarity between the PDP bill and the GDPR and the differences. Both include extraterritorial applicability. So any data fiduciary outside India who is collecting and processing data of an Indian citizen would become a data fiduciary under the bill. There are functionally similar concepts of the relevant parties vis-a-vis data fiduciary and controller, data principal, and the data processors. However, a significant data fiduciary and guardian data fiduciaries are concepts which are solely under the PDP bill. The rights of data principals, as discussed earlier, is largely similar. The privacy by design policy is largely similar. What is most relevant in differences and divergences is there is no separate category of sensitive personal data under the GDPR. So that is something. So there is a difference of compliances vis-a-vis an entity collecting sensitive personal data or versus an entity collecting personal information. There is an introduction of a concept called consent managers. This is something which is yet to be explored widely under the bill. There is a lot of power given to the governmental authority of the Data Protection Authority under the PDP bill. Age thresholds are different. Under the bill, it is 18 years, while under the GDPR, it's 16. Significant data fiduciaries, as I mentioned earlier, are separate categories under the bill. Then data transfer and data localization is a very controversial topic, which a lot of advisors under the GDPR have spoken about. What the GDPR requires is if an entity does not meet the adequacy if the country does not meet the adequacy standards, there are SCCs which apply. However, that is not the case over here. Data transfer is restricted. GDPR does not look at criminal penalty or criminal liability, whereas PDP does. And then the PDP bill introduces the sandbox mechanism. So these are very high level, just want to note, this is very high level of divergences and similarities. And obviously the finer nuances under each of these would need to be looked at on a case-to-case basis. Sangeeta, Satendra, may I request us to have this impact on Indian JVs, please?
Annie, thank you. But just before we move, I think when we were talking about localization of data, one of our audience had a very pertinent question around what is meant by localization of data and can that happen only in India? So I would just take up that questions given that's already come up, while we have some 10 minutes at the end of the slides also, but given this has come, I would just like to answer. Localization of data means basically storing of data. So the storing of data can take place only in India. So for example, you have all these well-known names, Amazon, LinkedIn, Facebook, dealing with data worldwide, and it's a voluminous data that they are talking about. So in that context, if you are dealing with those kind of data fiduciaries and data controllers, the data has to be stored in India. So that's a very small and simple example I'm trying to give. but in context of various, say, corporates, if you are, say, a high data processing company in Germany, and you do a brownfield meaning a joint venture program in India with a joint venture partner. In that case, given it's an Indian company and we are talking about the Indian data protection bill, your data will have to be stored in India. And I think when I'm dealing with this slide, impact on Indian JVs or foreign entities would also cover some aspect of your question here. So I'll just go through the pointers we've mentioned here on this one. When we say that data protection law, applicability of data protection law for multiple jurisdiction, what does that mean? So this is basically leading us to what is meant by an extraterritorial jurisdiction. So let me explain you this with the means of an example, because that will be much easier. So I'm an Indian national and I am traveling to Germany, and I sort of book a Uber in Germany. In that case, what happens is, while I am an Indian natural person, my data fiduciary and data controller is Uber in Germany. So in that case, I become, what becomes relevant is the Personal Data Protection Bill as well as the GDPR. Both of them become very relevant, and I, as a natural person, get the benefit of both the laws. And in that case, when you're talking about data fiduciary and data controller, the GDPR also equally becomes applicable, and I become a beneficiary of both the laws. There are very various examples I can give, but I'm cognizant about our time. So, whatever is pending, we'll take it up towards the end of it in the Q&A session, or maybe we'll come up with a solution how to sort of maintain the sanity of time. The second one, technology clauses. So, most of your companies, you all would have done joint ventures with various Indian partners, and, built in technology clauses and invested numerous number of hours and hours negotiating a technology clause. And critically, when we deal with the technology clause, we talk about the IP and we talk about the tax laws. But what interestingly introduction of data protection bill would do is I would say one more aspect and one more tier of compliance would get added to it, because usually what happens is these partnerships are synergies of expertise that take place. So for example, say an Indian partner would usually want to take the benefit of a technical expert situated in a foreign country. Obviously, there's going to be cross-border data. Obviously, there's going to be data that's going to cross the two countries. Now, where does the data sit? Again, it becomes a question of where does the storage of data takes place? How do we deal with data protection, that we are abiding by the data protection law when building in such clauses, in our JV contract? The third one we have been talking about, that localization of data, storing of data in India. So it's a very cost centric thing that we are looking at, and the slight worry that we have is how are our foreign JV partners going to look at it, because setting up data centers in India is going to be a costly affair, and specifically given the way the infrastructure as it stands today in India, it's not an easy task. So that is something that will have to be, and specifically it's not, I'm not so concerned or worried when I'm talking about the mid-size or the new size companies, but the giant companies that we talk about, they really deal with voluminous data, and setting up data center in India is going to be a challenge. While we are talking, I think the rich elite promoters whom Satyendra mentioned while laying the foundation have already started working on this aspect of getting new business to India. So I for the next point also I would request Satyendra to sort of pitch in, because we have I would just like to mention here that Satyendra is also an insurance specialist who leads our insurance practice in the firm. And given the last point is very, very critical, and it leads to sort of giving some introduction about insurance. Satyendra, I would defer for you to take up the last point, please.
Yeah. Thank you, Sangeeta. So, in the insurance world, as we say, that security is only a myth. And given the example of how GDPR has played out in Europe, we already see, large-scale breaches, making headlines, and so are the penalties that these organizations are facing. Now, it's So, given that India has made a significant departure in the GDPR, in our own version of the data protection law by, introducing the concept of criminal liability and also, emulating GDPR insofar as the penalties are concerned, 4% of global turnover. By the way, none of the Indian laws have, they speak this kind of language. And, so Indian lawmakers are taking the wrong kind of inspiration from GDPR, by the way. But having said that, there is, uh, a great degree of risk that companies would face, once this entire regime comes into force. So while technological interventions, while companies put into place technological interventions, while they ensure that their compliances are robust, but there will always be a possibility of breach. So in that case, how do you protect yourself? How do you protect your board, your senior management in terms of any kind of a liability that gets fastened onto them? And how do you protect your balance sheet, given that we are staring in the face of such huge penalties? So the only option there is insurance, and as you would know that the entire space and the entire universe of cyber insurance is now expanding to take into account the liabilities that the companies face, that emerge out of data protection and privacy related issues. One thing that that the participants should know about India is that when you are looking at uh, protecting or having insurance cover for the risks that emanate from India, under Indian law, you can only procure such insurance policies from India admitted insurance companies, which means that the risks that you intend to cover under your global program will need to be suitably modified as far as your Indian subsidiaries or Indian branches are concerned. So that is it from me from the cyber insurance point of view.
With this, I thank you, Satin. With this, I think we complete our presentation from an overall perspective. Annie, I would just like to summarize our presentation with our last slide, So for all the participants, all that we spoke in our above slide as we summarized in these 6 to 7 keywords. So and every time I get stuck with the last one, which is imprisonment and fine, and because it's going to have a direct impact on the balance sheet of our company and we become answerable to our management. So that's on the lighter note. But before we open the floor for the audience for question, I would just like to say a couple of things. I know that this is a topic that we cannot cover in 1 hour, and given the phase that it is today in India, and we being very certain that in next 6 to 8 months it's going to take its final shape, it's just about that introduction and the time that would be involved in setting the ground, given the nuances that surround between the proposed bill and GDPR. What we intend to do is we intend to hold some follow-up discussions, deliberations around this topic once in 2 months. So we can sort of work out some framework as to how we can sort of do this to ensure that you'll get the most of it and it's not left with just one brief introduction. So, you could contact us on the email ID provided in our presentation. The Chamber of Commerce will share the presentation with you once the slot is over. And you could connect with us and we could make you a part of our group where we would be having these deliberations and discussions. With that, I open the floor for Q&As. The first one happens to be, when is the Indian Data Protection Law and Act going to be effective, and what are the 3 key things that organizations should invest in? Satyendra, why don't you take up, because you have already laid the foundation for this question.
Yeah, right. So the law, in India, the lawmaking process takes the course of, so the bill is tabled in the parliament, and once both the houses of the parliament pass the bill, it gets notified in the Gazette, and then it gets implemented. Where we are right now is that the Parliamentary Standing Committee is deliberating on the bill, and the bill will need to be reintroduced in the Parliament. And once the Parliament, is able to pass the bill, then it will get notified, and the rule-based framework around the bill will also be notified along with it. So we are looking at anywhere between if on a conservative basis, we are looking at around 6 to 9 months before the bill actually the law actually comes into effect. Having said that, there is given that the bill was introduced before COVID, and after COVID, everything around has changed. History has changed forever. The government may even try and look at introducing certain cushions so that the law has a soft landing on Indian businesses, because the manner in which this law is going to change the entire compliance landscape. There is also a discussion within certain segments of the government that they will do whatever is necessary so that there is no radical adverse impact on the stakeholders. And on the three parts, if you could, if you could take up the second part of the question.
What are the 3 key things that organizations should invest in? Annie, would you like to take that up?
Yes, Sangeeta. So I think first and foremost would be identifications, wherein what would apply to an entity, and what would, I mean, the sort of entity that they would fall under, basis their business models, the sort of data they're going to be collecting. So such identification, I think, in my opinion, would become relevant. Over and above that, I would think obviously insurance would be something which one would needs to invest in, and with identification, I also mean auditing. And the third thing, I'm just trying to see what comes to mind.
And would it be a compliance team that they would like to sort into, where the training is being provided? Because with this kind of bill, training becomes extremely important, because one leakage in the system and everything is going to turn down directly into the management.
In fact, training should have come on the top of my list, because training at business levels, marketing teams, sales teams, depending on the kind of business that one is looking at, all of this becomes important. I mean, one would have CISO roles, DPO roles also in the entities. So all that training, which a GDPR compliant, even a GDPR compliant, counterpart in the EU would have, that sort of a training, which is also what we spoke about in the technology transfer clauses. So all sorts of trainings from experts and the foreign counterparts would then become relevant.
Exactly. The next one that we have is, what is the probability if for some reason data localization is not possible? Would there be a case-to-case basis adherence or solution by Data Protection Authority? So I'll take this up. As the bill stands now, I don't think so as far as data localization is concerned. The way the deliberations are going around and the way the report to the bill, the journey from report to the bill has taken place, and the way data localization has been concerned, it would be a case-to-case basis kind of an adherence. My personal inference towards that is, no, it won't be a case-to-case basis. It may be, it will be like a rule of law, and then there could be certain exemptions around it, and that could be something the Data Protection Authority could consider. But expressly allowing it on a case-to-case basis is something I do not expect that to sort of happen.
Also,
we have one more question. Sorry, yeah.
And over here, even sector regulations would apply, because say, for example, if someone is working in the banking space or the insurance space, sector regulators also have their requirements. So this
Exactly, very
would
good.
while this forms the underlying, the base of the data protection law, it would all need to be looked at in the context also, if at all there is a sector specific regulation which applies.
Right. The next question is, how will India organize cross-border transfer to Europe? Will India implement standard contractual clauses like we know them from the GDPR? My hunch to that will be the possibility does exist for something on similar lines coming, given this has not yet been completely explored. But as I stand now, the answer to that would be yes, the possibility does exist. There's one more question. In the GDPR, we have the joint controllership. Does the India data protection know something similar? Do we have something joint controllership? Not
No,
not
I
that
don't think so.
not that it's yeah, please, Annie, go for it. Please go for it.
If joint controllership means, like, there are two data fiduciaries involved parallelly, then yes, but then one data fiduciary, if it is giving certain data to another data fiduciary, all of the obligations will have to then kick in while the transition is happening. So I do not know if that answers the question, but that is what it would seem like.
The next one we have is, what are the most important differences to GDPR? The participant who has asked this question, we we will be sharing this presentation with you all post this session. There is a slide which covers the key differences, and like we said, we will be holding once in 2 months a session, because this is a question which will require some amount of involvement of time, and would not just want to answer it to you in a periphery basis, because it's going to take some time for you to understand the differences between the data protection bill, proposed bill, and the GDPR. So if we can take it up there. And if there's something extremely pertinent, Annie, could you want to mention a couple of points to the participants given the question has been raised?
Sure, Sangeeta. I think a couple of foremost things would obviously become data localization. It would be the criminal penalty which is involved under the PDP bill. The fact that there is no concept of sensitive personal data, and even in fact for that matter significant data fiduciaries which exist. So there is no sliding scale of compliances. There are very broadly defined categories under the GDPR. And I would think overall there is a lot of government intervention which has been provided under the PDP bill, more than what we see in the GDPR. Obviously, there are a lot of clauses which have been left to the interpretation by the member states under the GDPR, and they can have their own. There are certain openings which have been left there, but I think broadly you would see a very thin trend of government intervention and data protection authority intervention inside the PDP bill, more than what we can see under the GDPR.
Makes sense. Makes sense. I think we take up the last question for the day, which is, hi, thanks for the presentation. The first question you have is that sensitive data to cross the border must have explicit consent. How does this work with subcontractors? Can a person give general consent for subcontractors, which is very common in IT contracts? See, the possibility of this flying through by having a general condition could exist, but like we said, this is right now in the form of a bill. So my assessment is, given this is a bill, and there are do's and don'ts that will come around this framework. So it's not going to be like it exists today, like you just have a simpliciter general clause and you can take the garb of a general permission existing, and because the proposition that the question that you have about a general permission, the misusage of it can be very, very high. So the risk what they're trying to protect with introducing the data protection law sort of gets diluted. So my view is it would not remain like a common clause and a general permission format. There will be certain do's and don'ts around announced around it. And the second part of the same participant question is, Second question would be, which are the legal basis to process data? Annie, I sort of have not got it rightly. Have we got it? What is the legal basis for?
Yes, yes. So essentially, there are I would think 5. I'm going to look into the reasonable purposes for which one may process data. But as I understand it, there are about 7 or 8 processes which have been identified under the GDPR. We do have similar ones. It could range from, while there is a reasonability threshold provided under processing of sensitive personal data here, and if one reasonably expects processing to happen, that will suffice. Over and above that, there are things like mergers and acquisitions, network and information security. So I think this question we will, if this is put up in context, we will be able to give a much broader and nuanced view on this. But yes, there are certain lawful processes which have been identified under the bill. Broadly, it is a reasonable expectation of the data principle, but there are certain exceptions to reasonable expectation, and those are identified under the bill.
Thank you. Dear audience, I would now like to sort of conclude this session from our end. And I get there are many more questions that are still standing and you all would like us to answer. My request is that, when the presentation is shared with you people, there is an email ID and number that has been provided. You all can reach out to us on that email ID. We will soon be forming a group, which would where we would be discussing. There'll be deliberations, discussions around the data protection bill and how it's being taken and what's the formation that's being happening around it. If you wish to be a part of that group, I request you to write to us on that email ID so we can sort of, bring you up to date with the process that will be followed with this group. With that, thank you very much for being such a patient audience with us, and I hand it over back to Anna and Sabina.
Thank you very much, Sangeeta. So I would like to thank all our experts for their insights. Very, very fruitful information. Thank you very much. As you mentioned, if you have any further questions, kindly just send an email to us or to KHAITAN Legal Associates, and we will be happy to answer all your questions. So thank you very much, Sangeeta. Thank you very much, Satyendra and Annie. Thank you very much for all this kind of information. I hope you have a wonderful day. And if there's anything else, in regard to data protection or anything that comes to the Indian market, please feel free to contact us. Thank you very much.
Sure. Thank you very much. Thank you all. Thank you. Bye-bye.
Thank you.
Thank you. Bye-bye, everyone.
Bye-bye.
Bye.
Bye.